Hello everybody and welcome to our very first video on the English legal system. Now this is just a general introduction today. There will be more videos very shortly on the English legal system and they will go into different elements in more detail. So today we're just going to focus very briefly on 5 things. Legal and social rules, and what's the difference? Civil law, criminal law, sources of law, and then the functions of law. So the first area to look at are legal and social rules. What is law? A very basic explanation of law is that it is a set of rules. So what makes legal rules different from other rules? For example, social rules. The baseline for rules of law is that we're talking about morality. We're talking about moral duties. For example, murder is a criminal offence. Now what this reflects is that generally in society, murder is seen as a heinous crime, it's seen as an atrocious crime and one which needs to be punished. However, we do have to bear in mind that laws are not constant. Laws change according to the political will in the country and the time period that those laws are made in. When there is a change of law, this can quite often reflect a change in the public's opinion and that there has been a shift or an alteration of their moral values. One useful example here is concerned with the law regarding homosexuality. It has not always been legal in England and Wales to be homosexual. At one point it was illegal. However, the public's opinion changed. There was an alteration in their moral standpoint with regard to homosexuality and now it is legal. So legal rules are very much concerned with moral duties and morality. Social rules are concerned with the structure of how we behave as individuals in a society. So now let's turn to have a look at civil law. Now the English legal system contains both criminal law and civil law. And you may ask yourself, what is civil law? Civil law is basically non-criminal law. And this can then further be divided into other areas. For example, we've got tort law and we have contract law. Now these will be dealt with in more detail in later units. So what is tort law? Tort law is concerned with wrongs. And in fact, the word tort comes from the Norman French word, which means twisted or wrong. Now, contract law, this has 3 essential elements in order for there to be a contract. You need to have an agreement. There needs to be consideration, and there needs to be an intention to create legal relations. What happens when there are breaches of civil law in England and Wales or under the English legal system? When there are breaches of civil law, actions for these breaches are brought in the civil courts. Now there are 2 types of civil courts in England and Wales. Note that I have said England and Wales. Scotland has its own legal system. So the 2 types of civil court in England and Wales are the county court and the high court. Most civil cases are heard in the county court. There are exceptions to this, and the exceptions are when the case is of a high financial value, the case is complex, or the outcome of the case is of importance to the general public. According to the website gov.uk, and this is the 2021 statistic, there are currently 170 county courts in England and Wales. We then have the High Court. Now the High Court is made up of 3 divisions. There's the Queen's Bench Division. This is also referred to as the QBD. there's the Chancery Division, and there's the Family Division. As I said, there are 170 county courts in England and Wales. However, the High Court is located in one place, and this is the Royal Courts of Justice in London. Now let's have a brief look at criminal law. So criminal law has two main elements, and these both have Latin names. Now you'll notice on the slide that the Latin names have been written in italics. When we study law and we use Latin terminology such as actus reus and mens rea, we write that terminology in italics. So the two Latin names here are actus reus and mens rea. Now what does this mean? In order for there to be a crime, there has to be two elements. One is the guilty act, which is the actus reus, and then there needs to be a guilty mind. This is the mens rea. Now, one thing to bear in mind here is that although the actus reus is a guilty act, it can also be an omission to act. For example, if you are involved in a car accident and you fail to report that accident, you have failed to do something, you have omitted to act. This can also constitute actus reus. In addition, it can also be a state of affairs. For example, being drunk in a public area. Now, there are two main criminal courts in England and Wales. This is the Magistrates' Court and the Crown Court. It's the Magistrates' Court which deals with the vast majority of criminal offences in England and Wales. There are 77 Crown Courts in England and Wales. The more serious offences, such as rape and murder, these are heard in Crown Courts, not the Magistrates' Court. A jury in the English legal system is made up of 12 people. And it's the jury who decides whether the person who has been charged with the offence is guilty or innocent. Now, this person who is charged with the offence is known as the defendant. It's the judge who decides the questions of law. It's the jury who decides if the person is guilty or innocent. It is also the judge who will state the sentence which is to be passed upon the defendant. Finally, let's have a little look at some sources of law, and then we will look at the functions of law. So, sources of law, we have European Union law. Now, although the UK has now left the European Union legislation still has an impact upon English law. Any EU legislation which was in force before 11 o'clock at night, 11 p.m, on the 31st of December 2020 has been kept in UK law. However, it's now termed domestic legislation, even though it was originally EU legislation. I've just mentioned this term legislation. What does it mean? Who makes it? Legislation is made by the Queen in Parliament. Now, Parliament is comprised of three elements. It's the House of Commons, the House of Lords, and the reigning monarch, who in this case is Elizabeth II. A further source of law is judge-made law. Now, this is not made in the House of Commons. This occurs when a decision is made in a court, and then courts which are lower than that court or of equal status follow that judge's decision. This will not happen every time. This will only happen if the new case is similar to the previous case, and also that the new case is concerned with the same legal rule as the old case. The final source of law we're going to look at today is the ECHR, which is the European Convention on Human Rights. Now, this was adopted in 1950, and the UK did become a signatory at inception in 1950. However, the ECHR was not incorporated into English and Welsh law until the passing of the Human Rights Act in 1998. Even then, the Act did not come into force in 1998. It came into force in October 2000 in England and Wales. Finally, let's have a quick look at the function of law. There is a main function, which is that it maintains law and order in England and Wales. Now, the main reason for this is that if we didn't have laws, as Bamford, Taylor and Verlander note, that country may turn into a state of anarchy. And that is the main reason why we have law. Hopefully, you've enjoyed this little introduction today to the English legal system. I have some references here and also some legislation. If you enjoyed this video, please hit the subscribe button. There will be some more videos very, very shortly, and you will be notified when those videos become available. Thank you for listening today. Bye.